There's a moment in every legal battle when the ground shifts, when something that seemed solid suddenly isn't, when the calculus changes and everyone involved knows it, even if they won't say it out loud. We might be watching that moment unfold right now. Donald Trump has faced investigations before, multiple impeachments, criminal indictments, civil judgments, a political career built in part on defying legal consequences that would have ended anyone else. But what's emerging now is different, not louder, not more dramatic, just different in a way that matters. And the people who understand how power actually works in America are paying very close attention. Let me start with what we know, because facts matter here more than speculation. In the past 72 hours, multiple developments have converged in ways that create what lawyers call exposure. Real exposure, the kind that can't be dismissed with a press release or a Truth Social post. First, new testimony has emerged in one of the federal cases, not from a peripheral figure, not from someone with an axe to grind, from someone inside the operation, someone who was in the room when decisions were made, someone whose account directly contradicts previous statements made under oath by others in Trump's orbit. That matters because perjury isn't a political talking point, it's a felony. And when testimony conflicts this directly, prosecutors have decisions to make. Decisions about who's telling the truth and who isn't, decisions about who gets charged and who gets immunity in exchange for cooperation. Second, a ruling came down from a federal appeals court that narrows the legal strategy Trump's team has been relying on. The ruling doesn't eliminate his defense entirely, but it closes off an avenue that was supposed to push key decisions past the election, past the moment when political power might provide protection that legal arguments cannot. Timing matters in law. Delay is often the most effective defense, and when delay becomes harder to achieve, everything changes. Third, and this is where it gets particularly significant, there are reports of new grand jury activity, not the grand juries we already knew about. A new proceeding, different jurisdiction, different focus. The details are still emerging, but experienced legal observers recognize the pattern. When prosecutors convene a new grand jury at this stage, it usually means they have new evidence, new targets, or both. Now let's be clear about what this does and doesn't mean. This doesn't mean Trump is going to prison tomorrow. It doesn't mean his political career is over. It doesn't mean the cases against him are slam dunks that can't be defended. What it means is that the legal landscape is shifting in ways that create genuine risk, the kind of risk that can't be managed purely through media strategy or political pressure, the kind that requires actual legal responses to actual legal problems. And here's why that matters more than you might think. Trump's entire approach to legal jeopardy has been based on a few core strategies: delay everything, attack the prosecutors, turn it into a political narrative, rally the base, win back power, use that power to make the problems go away. That playbook has worked remarkably well. It got him through Mueller. It got him through 2 impeachments. It's kept him viable as a presidential candidate despite unprecedented legal challenges. But that playbook depends on certain conditions. It depends on being able to control the timeline. It depends on judges being willing to grant delays. It depends on the political calendar aligning with the legal calendar. It depends on maintaining enough political support that the legal system feels pressure to move cautiously. When those conditions change, the playbook stops working. Let's talk about the new testimony for a moment, because this is where the legal theory meets the factual record. Without getting into details that might identify the witness, what we're seeing is testimony that directly addresses intent, what Trump knew, what he was told, what he decided to do anyway. In criminal law, intent is often the hardest element to prove. You can show what someone did, you can show the outcome, but showing what they were thinking, what they intended, that usually requires witnesses, documents, communications that reveal the thought process. Prosecutors in these cases have been building that evidence methodically. Financial records, text messages, testimony from lower-level participants. But there's always been a gap, the gap between what staff did and what Trump himself knew and intended. This new testimony appears to narrow that gap, maybe even close it in certain areas, and that changes the risk calculation dramatically. Think about it this way. If prosecutors can only show that people around Trump did questionable things, the defense is simple: he didn't know. He relied on advisors. He was misled. That defense has worked before. It's worked for lots of powerful people throughout history. But if prosecutors can show that Trump was told something was illegal, was warned about the consequences, and did it anyway, that defense evaporates. You can't claim ignorance when people have testified that they specifically informed you. That's the kind of testimony that makes defense attorneys nervous, the kind that leads to plea discussions, the kind that changes everything. Now let's talk about the appeals court ruling, because this is more technical but equally important. Trump's legal team has been pursuing a strategy of asserting executive privilege, claiming immunity, arguing that former presidents can't be prosecuted for actions taken in office. Some of those arguments have merit. Presidential immunity is real for certain official acts. Executive privilege does protect some communications. These aren't frivolous legal theories, but courts have been systematically narrowing how those protections apply. And this latest ruling continues that trend. The court didn't reject immunity entirely, but it drew clear lines about what counts as an official act and what doesn't. Here's why that matters. Every time a court narrows these protections, it makes delay harder to justify. If the immunity argument isn't going to succeed, there's no reason to pause proceedings while it's litigated. If executive privilege doesn't apply to certain documents, there's no basis for withholding them. The strategy of delay depends on having legitimate legal issues that require time to resolve. When courts start saying those issues aren't as complicated as the defense claims, the delays stop. And that brings us back to timing. We're now at a point where multiple cases could potentially reach trial before the election. Not definitely. Not certainly, but possibly. And possible is very different from impossible. If Trump is on trial during the campaign, everything changes. Not just politically, though that's significant, legally. Because once you're in trial, you can't control the narrative the way you can in the media. Evidence gets presented, witnesses get cross-examined, jurors make their own judgments. You're in a different arena with different rules, and those rules don't favor people who've built their defense on public relations rather than legal substance. The new grand jury activity is perhaps the most intriguing development precisely because we know the least about it. Grand juries operate in secret. Prosecutors don't announce what they're investigating until they're ready to indict. Witnesses are prohibited from discussing their testimony in most circumstances. But certain patterns are visible even through the secrecy. When prosecutors convene a new grand jury, it signals forward momentum. They're not winding down, they're expanding. They've found something that warrants additional investigation and potential charges. There's been speculation that this new grand jury might be focused on financial matters. Others suggest it's related to obstruction. Some think it's about conduct that emerged during other investigations but falls under different statutes. We don't know, but we know it's happening. And we know that federal prosecutors don't convene grand juries casually. It requires authorization from senior officials. It requires resources. It requires a belief that there's enough evidence to potentially secure indictments. That's not nothing. That's a significant development that suggests the legal pressure is intensifying, not diminishing. Now, let's talk about what this means politically, because law and politics are deeply intertwined in this situation. Trump is currently the leading Republican candidate for president. He's running explicitly on the narrative that he's being persecuted by a weaponized justice system. His supporters see the legal cases as proof of a conspiracy against him. That narrative has been effective. It's energized his base. It's raised enormous amounts of money. It's turned what could have been a political liability into a political asset. But that narrative depends on the cases seeming political rather than legal. It depends on people believing the prosecutions are baseless, motivated by partisanship, lacking in real evidence. What happens when the evidence becomes harder to dismiss? What happens when testimony from Trump's own people contradicts his public statements? What happens when courts keep ruling against him, not on technicalities, but on the merits? The political calculation starts to shift, not for everyone, not for his core supporters, but for the persuadable middle, for Republicans who've been willing to give him the benefit of the doubt, for independents who don't follow every detail but react to the overall trajectory. If the legal problems start to look genuinely serious, if they start to interfere with the campaign in practical ways, if they create uncertainty about whether he could actually serve if elected, that matters. And here's the thing about political momentum. It can shift faster than people expect. What seems inevitable one month can collapse the next. We've seen it happen before in American politics. Frontrunners who seemed unstoppable suddenly weren't. Trump is not a typical candidate. His support is unusually resilient, but it's not infinite. And if the legal situation deteriorates significantly, if trials begin, if convictions occur, even his resilience has limits. None of this is certain, none of it is predetermined, but the possibility is real in a way it hasn't been before. And political actors are starting to plan for multiple scenarios, including ones where Trump isn't the nominee or where he's significantly weakened going into the general election. Let's talk about what happens next, because that's what matters most. In the near term, we should expect several things. First, responses from Trump's legal team to these new developments. They'll challenge the new testimony, they'll appeal the court ruling, they'll try to block or delay the grand jury proceedings. That's their job, and they're good at it. Trump has excellent lawyers working for him, and they'll use every tool available to defend their client. But second, we should expect prosecutors to move forward systematically. They're not going to be deterred by political pressure or media criticism. They're going to build their cases, present their evidence, and let the legal process run its course. The question is whether that process runs its course before the election or after. And that question is increasingly looking like it might be answered in the before column rather than the after column. Third, we should expect political ramifications. Other Republican candidates will have to decide how to respond. Do they attack Trump more aggressively? Do they prepare for a scenario where he's not the nominee? Do they defend him to maintain support from his base? Republican Party officials will have to game out contingencies. What if Trump is convicted before the convention? What if he's on trial during the general election? What if he wins the nomination but becomes unelectable because of legal problems? These aren't hypothetical questions anymore. They're planning scenarios that serious people are seriously considering. And fourth, we should expect this to affect Trump's own decision-making. Does he double down on the combative approach? Does he consider any kind of resolution to reduce legal exposure? Does he change his campaign strategy to account for potential legal constraints? Those are deeply personal decisions that only he can make, but they're decisions that are becoming more urgent as the legal situation evolves. Here's what makes this moment different from previous crises Trump has faced. This isn't about political opponents. This isn't about media coverage. This isn't about public opinion polls. This is about the legal system operating according to its own logic and its own timeline. Prosecutors who have spent years building cases, judges who are making rulings based on law, not politics, grand juries that hear evidence and make decisions in secret. And Trump can't tweet his way out of this. He can't hold a rally that makes it go away. He can't fire the people investigating him the way he could as president. He's operating in a system where his usual advantages don't apply, where his ability to dominate the narrative is limited, where delay only works if courts allow it, where the outcome depends on evidence and legal arguments, not political power. That's unfamiliar territory, and it's territory where the risks are real. Now, does this mean Trump is finished? No. He's survived situations that would have destroyed other politicians. He has resources, determination, and a base of support that remains intensely loyal. He could still win the Republican nomination. He could still win the presidency, but the path is narrower than it was. The risks are higher. The margin for error is smaller, and the legal problems that once seemed manageable are starting to look like genuine threats. That's not wishful thinking. That's not partisan analysis. That's an assessment based on legal developments that any experienced prosecutor or defense attorney would recognize as significant. We're watching something important unfold. Not dramatic, not loud, just important. The question is whether we're watching the beginning of the end of Trump's political career or just another chapter in a story that keeps defying expectations. We'll know more in the coming weeks and months. But what's clear already is that this isn't just noise. This isn't just another round of investigations that will fade away. This is different. The ground is shifting, and everyone involved knows it. Pay attention to what happens next, not to the rhetoric, not to the spin, to the actual legal developments, to the court filings, to the rulings, to the testimony, because that's where the real story is. And it's a story that could reshape American politics in ways we're only beginning to understand. The game might not be over, but it's entered a new phase. And in this phase, the rules are different, the stakes are higher, and the outcome is far less certain than either side wants to admit.